All right, this is case number 24, CR 43, State of Ohio versus Waylon James Stratton. Are you Waylon James Stratton, appearing there from the jail? Are you Waylon James Stratton?
Yes, sir.
Okay. This is a hearing to set for a plea by Zoom. Mr. Stratton's appearing from the jail. The defendant is the defendant's attorney, Jeffrey Blosser, is appearing from his office, and appearing from the prosecutor's office to represent the state is prosecuting attorney Collins. The defendant is charged with 5 counts of rape. Now, Ms. Collins, has the representative of the alleged victim been notified of the time, place, and purpose of this hearing and the right to be heard?
Yes, Your Honor. The caseworker in charge of the victims has been notified and likely is watching on YouTube.
All right. Now, Mr. Blosser, are you and your client both in agreement that this matter can be conducted by Zoom rather than an in-person hearing in the courtroom?
Yes, sir.
And you're all right with that, Mr. Stratton?
Yes.
Now, since you're not seated in the courtroom next to your attorney, Mr. Stratton, if at any time you would like to talk to him, ask him any questions, etc., you just tell me, and then I will put the two of you into what's called a breakout room. It will be just you and he on the screen talking. None of the rest of us will be able to see you or hear you, and the deputy will step out of the room during your consultation with your attorney, okay?
Yes.
All right. Now, Mr. Stratton is charged, as I said, with 5 counts of rape, 5th-degree felonies, and the court was informed that the parties reached an agreement, and so the matter was set for trial today, or for hearing today. Mr. Stratton, I have this form here that's a plea of guilty form, which says you're going to enter a plea of guilty to count 1. I'm going to hold this first page up to the screen, to the camera, and do you recognize that first page that has your name, case number, says plea of guilty?
Yes.
We're not showing up over here. The third page, there's a line right below the paragraph that reads, I enter this plea voluntarily, and I'll hold that up to the camera and ask you if that is your signature right there.
That is.
And when did you sign this, Mr. Stratton?
I signed it the other day when my attorney come to see me.
All right, and when you signed it, did you understand that it was an agreement to plead guilty, which means there's not going to be a trial? The next step in your case would be a sentencing hearing?
Yes, sir.
And did he go over this with you and explain everything to you before you signed it?
Yes, sir.
Do you feel that you were pressured or rushed in any way into doing this?
No.
And since it's been a few days since you signed it, is this still what you want to do?
Yes.
Did you sign this agreement voluntarily?
Yes, sir.
And are you going forward today with the plea voluntarily?
Yes, sir.
All right, now the agreement states that you're going to plead guilty to the first count of the indictment, which is rape under section 2907.02A1B of the Ohio Revised Code. It's a first-degree felony. And that has because of the nature of the offense, it has a special sentence, and the sentence in this case is a mandatory term of 10 years up to life. And so what that means is that you would have to serve a minimum of 10 years, less any good time credit that you have accumulated. I'm sorry, jail time credit, not good time. I'm showing my age here. Then after that, you could be considered as eligible for parole and post-release control by the parole authority, but it would be up to them. But potentially, you could spend the rest of your life in prison. And there's also a $20,000 fine. Do you understand that?
Yes, sir.
Now, in addition to that, there is also a requirement that you be designated as a Tier 3 sex offender, which means that if you should be paroled or released from prison during your life, you would be required to register as a sex offender for the rest of your life and comply with those laws. You understand that?
Yes, sir.
All right. Now, are you facing any felony charges in any other jurisdiction?
No.
Are you currently on probation, parole, post-release control, or probation from any county?
No.
All right. Now, And again, under the law, there's provisions for community control and so forth that are on this form, and those don't apply because it's a mandatory sentence. You understand that?
Yes, sir.
All right. Now, if you are paroled after serving at least 10 years by the Adult Parole Authority, it is mandatory that you be put under post-release control supervision for a period of at least 5 years. So if they let you out early, you would be required to be supervised for 5 full years by the parole authority, by a parole officer, under the terms that they set. And if during that period of time they determine that you have failed to comply, they could return you to prison to make you serve an additional period of up to 9 months for any single violation. It would be a maximum or cap of half of your prison term for all violations. But if you should commit a new offense while under post-release control, then in addition to whatever sentence a judge in that new case can impose upon you, the judge could also sentence you for committing that offense while under post-release control, in this case, to an additional period of a year, whatever time is left on that period of post-release control, whichever is greater. If that occurs, that has to be served consecutively to the sentence in the new case. Do you understand that?
Yes, sir.
Now, the indictment in this case reads in count 1, on or about October 20, 2019, continuing through October 19, 2020, in Highland County, Ohio, that you did engage in sexual conduct with a person identified as V, date of birth 10/20/2009, was not the spouse of said Waylon James Stratton, or being the spouse, but living separate and apart from the said Waylon James Stratton, and the said V being less than 13 years of age, whether or not Waylon James Stratton knew the age of V, in violation of section 2907.02 A1B of the Ohio Revised Code. So that's the charge of rape, a first-degree felony with a sentence of mandatory prison term of at least 10 years up to a maximum of life, $20,000 fine, and a lifetime designation as a sex offender should you be released from prison. Now, Mr. Stratton, you understand the charge and the possible penalties?
Yes, sir.
And you understand what the state said you did, when, where, and how they alleged that you did it?
Yes.
Now, have you discussed the nature of the charge, the evidence in the case, the possible legal issues in the case, the possible defenses you might try to raise at trial, and the possible outcomes of a trial with your attorney?
Yes.
Are you satisfied with his advice and competence in this matter?
Yes.
Are you under the influence of any types of drugs or alcohol at this time?
No.
Have any threats been made to make you plead guilty here today?
No.
Now, on page 2, there is a couple of lines that printed in bold and underlined that read as follows. Defendant will enter a plea of guilty to count 1. State will dismiss remaining counts. The state and defense jointly recommend 10 years to life. Defendant shall be a Tier 3 registered sex offender. Is that your understanding of the agreement?
Yes, sir.
Has anyone promised you anything other than that to get you plead guilty here today?
No.
Now, Mr. Stratton, do you hold any kind of a license or certification from any state governmental agency that regulates any occupation or profession in the state of Ohio?
I'm a Team 40 firefighter, and I've got my basic EMT certification.
All right. Well, the court would have to, the clerk of courts will have to notify that board of your conviction if you are convicted, and then that will potentially lead to some sort of action on your license. And so you understand that that could also happen as a result of a conviction.
Yes, sir.
All right. Now, you have certain constitutional rights you must understand before I can accept your plea. First of all, you have a right to have counsel, and Mr. Blosser was appointed to represent you, not simply to work the case out, but to provide any defense that may be available to you under the law that you would like him to provide. So, if you decide that you do not want to plead guilty here today, that you would rather defend against all 5 of the charges, he'll continue to represent you and defend those charges, including a trial, if that's what you want. Do you understand that?
Yes.
Now, under the Constitution, you have a right to have a jury trial on this charge, in which 12 people will be selected from a group of citizens that live in Highland County that are summoned for jury duty on your trial date. After they are selected, the evidence will be presented, and then that jury would be instructed on the law. And then that jury would have to decide by a unanimous verdict, meaning all 12 of them would have to agree, as to whether or not the state proves your guilt. Now, if you didn't want to have a jury trial, but you didn't want to plead guilty, you can waive or give up in writing your right to have a jury trial. And then you would have what's called a court or bench trial, meaning that instead of a jury hearing the evidence, the judge would hear the evidence, the judge would apply the law, and the judge would decide whether or not the state proved your guilt. Do you understand that?
Yes, sir.
Now, under the Constitution, you have a right to confront the witnesses against you and to cross-examine them through your attorney. What that means is that the witnesses against you have to come into court and testify in public in front of you and your attorney and anyone else may be present or watching. After the prosecutor's done asking questions, your attorney can ask questions. That's called cross-examination, the purpose of which is to bring out evidence that helps your side of the case. Do you understand that?
Yes, sir.
Now, under the Constitution, you have a right to use the power of the court to compel or force witnesses to come into court to testify for you, the same as the state. So if you have witnesses you're not certain are going to come in voluntarily, at your request, the court issues a court order, that's called a subpoena, and that forces those people to come to court to be able to testify if you want them to, even though they don't want to be here, which is the same way the state's witnesses are required to come into court to testify against you. Do you understand that?
Yes, sir.
Under the Constitution, you have a privilege against self-incrimination, Mr. Stratton, which means you cannot be forced to give evidence in this matter at any time, including trial. No one can ever make you testify. The prosecutor can't, the judge can't. You make the decision. If you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person, and no one can even talk about it except in one situation. If there's a jury trial and you do not testify, the judge instructs the jury that because that is your right, they cannot consider it for any purpose. Do you understand that?
Yes, sir.
Now, under the Constitution, you are presumed innocent of this charge until proven guilty by the state of Ohio on every essential element of the offense charged. So what that means is that the burden of proof isn't on you to try to prove you're not guilty simply because you've been accused of this offense. In fact, under the law, you don't have to prove anything at trial, put on any evidence at trial. You may, but you're not required to. But whether you do or not, the burden of proof will remain upon the state to prove your guilt on every essential element of the offense charged by proof beyond a reasonable doubt, which is the highest burden of proof that's known under the law. Do you understand that?
Yes, sir.
Now, originally you entered a plea of not guilty, Mr. Stratton. A not guilty plea denied the allegations in the indictment, denied you committed a crime, and it exercised or invoked all the rights I just described. If you change your plea today to count one, to guilty, that is the opposite of the not guilty plea. Guilty plea denies, or the guilty plea admits the allegations set forth in count one, admits that those acts constitute a crime and that you committed that crime. And that plea waives or gives up all the rights that I've just described for you today, except one, your right to have an attorney. You always have a right to have an attorney no matter what your plea. But with that exception, your plea of guilty would waive or give up your right to a jury or a court trial. It would waive or give up your right to confront the witnesses against you and to cross-examine them through your attorney. It would waive or give up, you can come in. It would waive or give up your privilege against self-incrimination, because if you say you're guilty, that's what's used to find you guilty. It would waive or give up your right to use the power of the court to compel or force witnesses to come into court to testify on your behalf, the same as the state. It would waive or give up your presumption of innocence, because if you say you're guilty, the state's not required to prove you're guilty. It subjects you to being sentenced immediately by the court, which is what's likely to happen. And finally, it waives or gives up any right to file an appeal you think you may have had up until this point in the case. Now, if I sentence you to the maximum sentence, or under other certain circumstances, you may file an appeal. That appeal will have to be filed within 30 days of your sentencing entry being filed. Do you understand all of that?
Yes, sir.
And are you a U.S. citizen, Mr. Stratton?
Yes, sir.
Now, do you have any questions about the charge or the possible penalty?
No, sir.
You understand it?
Yes.
Do you have any questions about the plea agreement?
No.
You understand it?
Yes.
Do you have any questions about the constitutional rights I've explained?
No.
You understand that?
Yes.
Do you have any questions about the guilty plea, or what it means, what the consequences of that will be if you entered here today?
No.
And again, you understand that the charge to which you're pleading carries a mandatory prison term of at least 10 years up to life. There's no discretion for anything else.
Yes, sir.
Okay. Now, is there anything you'd like to speak with Mr. Blosser about before we go any further?
No.
You have any questions about anything I've explained to you?
No.
Then is it your decision to withdraw your not guilty plea and plead guilty to count one pursuant to the terms of the plea agreement that we've just reviewed?
Yes, sir.
All right. Then as to the charge in count 1, which alleges that on or about October 20, 2019, continuing through October 19, 2020 in Highland County, Ohio, that you did engage in sexual conduct with V, date of birth 10/20/09, not the spouse of said Waylon James Stratton, or being the spouse of said Waylon James Stratton, but living separate apart from said Waylon James Stratton, and the said V being less than 13 years of age, whether or not Waylon James Stratton knew the age of V, in violation of section 2907.02A1B, the charge of rape, first-degree felony, carrying a mandatory prison term of at least 10 years, the maximum of life, a fine of $20,000, and a requirement to be designated and comply with Tier 3 sex offender designation should you be released for the rest of your life. How do you plead?
Guilty.
All right, thank you. Court finds that on this day in open court, the defendant was advised of all his constitutional rights, made a knowing, intelligent, voluntary waiver of the same, pursuant to criminal rule 11. Pleas accepted and order filed. Defendants found guilty of count 1 as charged. Counts 2 through 5 are dismissed. All right, there's no reason for the court to order a pre-sentence investigation since there's only one sentence that's mandatory, and so the court will go ahead and proceed with sentencing. However, before I do that, Mr. Stratton, it is necessary for me to inform you of the obligation to register as a sex offender. And your residence is Leesburg, correct?
Yes, sir.
All right. What's that street address?
131 North Fairfield Street.
Let's see, what is that? Is that 45135?
Yes, sir.
All right. Mr. Stratton, because of your conviction for rape under 2907.02A1B, you're hereby designated as a Tier 3 sex offender child victim register. That means that you'll be required to comply with registration requirements for your life should you be released from prison. And that will require you to verify in person every 90 days with the sheriff. Now, if you are released from jail, you will be required to register in person with the sheriff of the county in which you establish residency, which right now would be Highland County, and so that'd be at 130 Homestead Drive in Hillsborough. And that means that you would have to report to them and register within 3 days. You'll also be required to register with the sheriff of any county in which you may be working, if you work in that county more than 3 days consecutively or 14 days in a calendar year. And if you should establish employment or should go to a place of education in a different county, you would also be required to register with the sheriff of that county. So you could be required to register in 3 different places: where you live, where you're working, and where you're going to a place of education. And for purposes of employment, that includes volunteer service or community service. Now, in the event that you are living, working, or going to a place of education in a different state, then your obligation to register would apply in that state. You would have to register either with the sheriff or whatever public official or office that that state has that maintains and monitors sex offender registrants. In the event that you are going to be gone from your place of residence for 7 days or more, such as going on a vacation or going to visit family or perhaps being hospitalized for some sort of treatment, you're required to notify the sheriff of your residence, of where you will be, how long you'll be there. You're also required to verify your registration, as I said, every 90 days. You can't do that any earlier than 10 days before that. So it'd be the window is every 80 to 90 days, and you must then verify your residence address, place of employment, place of education, and you have to go there in person to the sheriff of the counties or counties in which you're registered. Now, if you change your residence, place of employment or place of education, you're required to notify the sheriff or sheriffs where you're registered of those changes as well. And if you're going to move to a different county or establish a place of education in a different county, you have to notify them at least 20 days in advance of your change of address for your residence and your employment. And you have to notify them not later than 3 days after your change of employment, because you can work in another location for 3 days before you're required to notify them. Now, if at any time you should not have a fixed address, then you must provide a detailed description of the place or places that you intend to stay. And then not later than the end of the first business day, immediately following the day you do obtain a fixed address, you must register with the sheriff that fixed address. Under federal law, you're also required to report any plans to travel internationally to your registering authorities, and it has to be at least 21 days prior to travel. If you don't do that, you could be subject to being prosecuted under both federal and state law. You're required to provide written notice to the sheriff or sheriffs where you're registered within 3 days of any change in your vehicle information, email addresses, internet identifiers, or telephone numbers that are registered to you or used by you. Now, in the event that you fail to register or notify your registering authorities of any changes as I've advised you, or if you fail to comply with any of the other conditions that I have gone over here with you, then that would subject you to being prosecuted for a felony under Chapter 2950 of the Ohio Revised Code, which would be felonies. And as I indicated earlier, you are required to register within 3 days after you're released from prison, should you be released from prison. All right. I am going to, I've signed this form that indicates I've explained this to you. We will fax that out to the Sheriff's Department, Mr. Stratton, and the deputy will have you sign it and fax that back so it can be placed in the file. All right, now the court will proceed with sentencing. Mrs. Collins, on behalf of the state, anything you'd like to say?
Yes, Your Honor, we would ask the court to follow the joint recommendation. We would note that we've been in close contact with the victim in this matter for obviously since the day the report was made, and she appreciates as well as the witness appreciate that this is being handled this way to avoid them having to go to trial. And we do recognize the defendant's willingness just to take responsibility for his actions and not force this victim to go to trial and talk about what happened. That being said, it's a very serious offense, and we feel that this plea agreement is appropriate based on the serious nature of the offense. Thank you.
Mr. Blosser?
Your Honor, thank you. We would just ask the court to follow the joint recommendation in this matter.
All right, Mr. Stratton, is there anything you would like to say? Anything you'd like to say, Mr. Stratton?
Yeah.
All right, well, go ahead, I'm sorry.
No, not this time.
All right. Then it is the order and judgment of the court that you be and are hereby sentenced to the Correctional Reception Center at Orion, Ohio, for a mandatory term of at least 10 years with a maximum term of life. Should you be released on parole, you'll be under post-release control also for a period of a mandatory period of 5 years. And those will be under terms set by the parole authority, and if during that period of time you fail to comply with any of those conditions, they could return you to prison to make you serve an additional period of up to 9 months for any single violation, up to a maximum of half of the prison term, which would be 5 years for all violations. However, if you should be convicted of a new felony while under post-release control, Then in addition, whatever sentence the judge in the new case can impose upon you, that judge will also be authorized to sentence you for committing that new felony while under post-release control in this case to an additional period of a year or whatever time is left on the post-release control, whichever is greater. If that occurs, that has to be served consecutively to the sentence in the new case. And according to the sheriff record, you were arrested on January 25th, is that correct?
Yes, sir.
All right, so that is 103 days of jail time credit will be applied to the 10-year mandatory minimum. You're also owed to pay the court costs, which judgment, grant, and execution is ordered. If you don't do that, the clerk can collect that through various means, including levying on bank accounts, wages, earnings, other assets you may have. If that doesn't collect it, then upon completion of your prison term, not while you're in prison, the court could permit you to do community service and give you credit for each hour you work in an hourly rate set by the court. Each hour you work will reduce your judgment by that amount until paid in full. Counts 2 to 5 of the indictment are dismissed. And as indicated, the defendant is designated as a Tier 3 sex offender. All right, is there anything further from counsel?
No, Your Honor.
All
No,
right.
Your Honor.
You're remanded to custody, Mr. Stratton, for conveyance to the Correction Reception Center to serve your sentence. Thank you. All right, fax this out to the jail